From day one, when a client calls and our intake department starts gathering information, that's just the infancy stage. And from there to go all the way to trial can take years. Because throughout that time, it's, the client may say, hey, it's really simple. This is what happened, that's it. But here's the thing, throughout the time we're in a lawsuit, it takes years to do the discovery process, which is basically where the defense is saying, well, give us all the medical records and give us any witness information. And we want to depose and have the witnesses testify, or the plaintiff testify, or the person who was injured to testify, and vice versa, right? If we're saying, hey, you know what? You may have a contract saying that so-and-so company was supposed to keep this property clear. And, we have to figure out, did they try to shift the responsibility onto somebody else? And is there somebody else who actually may be responsible other than, say, the owner of the property? So when we ultimately get to the point where it's ready for trial, we file what's called a note of issue. And that's pretty much saying to the court, we're done with gathering information called discovery. And with whatever we got now, we want to go to trial. In pre-COVID days, from the moment you filed the note of issue, the court would set a date, or they would have an ideal date for the case to resolve, whether it's settled or go to trial, 15 months, 1 year and 3 months from the date of filing the note of issue. So when people are like, why does it take so long? Well, just from the time we're saying we're ready to go to trial, we have to wait over a year to even get a trial date. So that in and of itself, with the court procedures, the court process, that's why it takes long. Also, to get ready for trial, there is a lot of things that need to be done to make sure that we get all the evidence in all our ducks in a row, because if you don't get all your ducks in a row and follow all the procedures, a simple thing of saying, hey, you know what? I want this piece of paper that's like our smoking gun to be the thing that's going to win our trial. If you didn't follow the procedural steps, the other side, objection, Your Honor, it's inadmissible evidence. Judge says, yeah, sorry, you can't use it, counsel. And that's why you have to follow a lot of different tiny little rules, technicalities, to make sure that we are ready and we have everything we need to try the case. And that's just the technical aspect. Now there's the art of trial, of communicating with a jury and presenting your story in a light that really has a juror wanting to become the heroes of the story to help the injured person and bring them to a place that is close as possible to where they were before all this happened. It's not easy, it's not easy. And it requires a lot of work.